I would dare say that the case we have brought is very clear on the face of the petition. If you read the petition, it is very clear why we have brought this matter. Now, in respect of the figures, we made it abundantly clear from the beginning that these were figures compiled by and announced by the Electoral Commission. You remember that we wanted to inspect documents. Our request was not granted. You remember that we wanted her to answer interrogatories, which are allowed under Order 22 of the High Court Civil Procedure Rules. At first, they said they were not applying CI 47, and subsequently, they had to rely on CI 47 to save themselves. All right? They did not permit us to. They did not permit us to administer the interrogatories. These are all mechanisms allowed by law to elicit evidence. And I don't see why the petitioner in this case, or anybody filing a petition as a citizen of Ghana in this case, cannot obtain information from the person who conducted the election for purposes of proving that the declaration she made was unconstitutional because none of the candidates obtained more than 50% of the votes. And let me say this, you see, there is a tendency, and I think that is where we have all gotten it wrong. Okay? I gave the example of Sixtus, you know, as an ordinary citizen mounting this challenge. Could the court have asked Sixtus to go to all the 275 constituencies and bring pink sheets? But read Article 64, Clause 1 of the Constitution. It says any citizen of Ghana may bring an action. So you can rely on the evidence compiled by and announced by the chairperson. In fact, in any jurisdiction, having seen situations of multiple summary sheets coming from regions, having seen situations of pardon, vote pardon, and admission of vote pardon by the respondents themselves, the court itself would have ordered an inquiry into the extent of vote pardon. And that would have not been based on our figures, it would have been based on the figures compiled by the Electoral Commission. And by the way, no party that goes into an election produces figures. The official figures are produced and announced by the Electoral Commission of the Republic of Ghana. Why is the commission not throwing that evidence to all of us to say, look, here it is, this is what we did, now tell us why we were wrong? Why are they not doing that? And why is it that you as journalists are not asking that question of the Electoral Commission? You know, the notion that just because the principle of law is that, you know, he who alleges must prove, then it means that because the petitioner has come to court, he must produce the evidence by himself. Cross-examination is one way by which you can prove that burden. Why are they running away from cross-examination? Why are they running away from bringing evidence? And by the way, we filed a notice to admit facts. Okay? The law is that after 14 days, if you don't answer, if you don't admit, those facts are deemed in law to have been admitted. All right? So, in fairness to the petitioner, the facts enumerated, you know, for admission are deemed admitted. And let me say this. You see, they have decided they are not giving testimony. What is the legal consequence of that? It means that our petition and the evidence led in proof of the petition stand unrebutted. That is the position of the law. And let anyone come and challenge me that that is not the position of the law. The court should have actually gone ahead to strike out their figures, their witness statements and their pleadings. Why is the court not doing that? That is a legitimate question that the petitioner is entitled to ask.